Remember Bibaa Henry and Nicole Smallman, sisters who were murdered in Fryent Country Park, Wembley, northwest London in June 2020, where police officers decided to take photos of the bodies and share them. Now, I reported on this on the 12th of May when the two police officers involved appealed their jail terms of 2 years and 9 months each, which was given by the Old Bailey. At the time, the appeal was rejected. Well, thanks to court rulings and the common law, whose channel I'll link to in the description, I have the Court of Appeal ruling now, and there's an awful lot of information within that the media didn't report and likely never will. So I thought I would share that with you in this particular report. So it's a bit of a change from what I normally do. But please be aware that the contents of this video may be distressing to some of you. Not because of images, thank God, but because, I wouldn't do that to you, but because what I have to say in this report about 48-year-old Deniz Jaffer and 33-year-old Jamie Lewis, both now ex-Metropolitan Police, is pretty disgusting. On the morning of June the 6th, 2020, Nicole Smallman and her sister Bibaa Henry were brutally murdered in a park in northwest London after the pair had been to an outdoor party with friends on June the 5th to celebrate Bibaa Henry's birthday. After the last guest left at around midnight on June the 6th, the sisters were left alone in a park where they were, unfortunately, subsequently stabbed to death by 19-year-old Danyal Hussein, who had written a pledge in blood to a demon to kill a woman every 6 months under the belief that this will allow him to win the lottery. The following day, Bibaa and Nicole's friends returned to the park worried about the fact they had not made it home or been seen since the night before, where they discovered the sisters' bodies in a small strip of trees. Police were of course called, and to preserve evidence they erected some cordons around the scene, one directly outside the hedgerow where the bodies were, and another some distance away to prevent members of the public contaminating the scene or being able to see what was going on. At approximately 3:30 on the 8th of June, meaning that the women's bodies had been in situ since the early morning of the 6th, Deniz Jaffer and Jamie Lewis arrived, tasked with guarding the scene with other police officers. Jaffer and Lewis were tasked with securing the inner barrier just outside the hedgerow where the bodies of the sisters still lay. It said they were not wearing full forensic barrier clothing, as in paper suits, shower caps on their feet, or a mask, and were told the approximate location of the bodies, but were not shown the bodies, as they had no reason to enter the hedgerow. At one point, another constable, PC Aspergenis, left her post and went to speak to Lewis, who proceeded to shine his torch into the bushes and show her where the bodies were, indicating that he had been in the bushes for a look. During a break time between 5 AM and 6 AM, Lewis, Jaffer and Aspergenis, along with another colleague, PC Wilson, drove to a nearby petrol station for refreshments. On that journey, Lewis shared a photo he had taken of the women's bodies with PC Wilson and later showed the same image to a probationary officer who said she was disgusted and told him that she didn't think it was appropriate to show such images. After Lewis and Jaffer were found out, forensic examination of their phones showed that Lewis took 2 images of the crime scene and that Jaffer took 4. In addition, Lewis created an image on his telephone on which he superimposed his own face in front of the bodies of Bibaa and Nicole. Both Lewis and Jaffer were members of 2 WhatsApp groups, one called the A-Team, made up completely of police officers, and another called COVID Cunts. There were 41 members in the A-Team group and 10 in the COVID Cunts group, of which Jaffer was the only police constable. On the 8th of June, Lewis has sent a series of messages to the A-Team group, including a link to a Daily Mail article about Bibaa and Nicole, along with the message, "Me, Izzy, Dennis and Matt are living the Wembley dream." Although in that particular message, none of the images of the bodies were shown. An image was attached of the park showing grass but not the bodies, and was an image of the park showing a tent but not the bodies. Another officer responded saying, "Enjoying the sunrise." Lewis responded, "Unfortunately, I'm sat next to 2 dead birds full of stab wounds." Jaffer sent images to the COVID Cunts group, in which he sent the same link to the article and a message that read, "I'm here now. We'll try to take pictures of the 2 dead birds." A further message read, "This is my view now. where he attached a photo of the scene, but that particular image did not show bodies in the picture. At 3:58 a.m. on the morning of June the 8th, one of the police members of the A-team group sent a message in apparent reference to Lewis's use of the words dead birds, saying who's been out stabbing pigeons. Lewis replied with a picture image of a man with pigeons on his shoulders. He then took a picture of the bodies of the two women visible in the background. At 4:29 a.m, Jaffer sent two images to Lewis, both of which this time showed the bodies of the sisters, and 2 minutes later Lewis used Snapchat to create a selfie of himself in front of the bodies. At 5:10 a.m, Lewis took another closer photo of the women, and almost 30 minutes later Jaffer sent 4 WhatsApp messages showing the women on the ground to PC Aspergenis, which included the selfie image from Lewis. At 7:10 a.m, Jaffer sent a message to a friend who was not in the police and asked if they wanted to see the 2 dead bodies. He also posted in the COVID Cunts group a link to an article saying that he had pictures of the dead women and asked the members to let him know if they wanted to see it. A friend replied, "Yes, what happened?" Jaffer responded with a message which said, "The best picture of the 2 dead victims, both stabbed to death in broad daylight and dragged up the trees. One is 14 and one is 20. She is pregnant." Now, the ages of the women in that reference and the reference to pregnancy were wrong, as were being stabbed in broad daylight. He then sent a message to the friend which contained an image of the 2 women. At approximately 4:10 a.m, Lewis sent 2 photographs of the park without the bodies being identifiable to a female friend and told her that he was sat next to 2 stabbed up dead women. The women's bodies were not visible from the path on which Lewis and Jaffer should have been standing, and so it would not have been possible for them to take photographs from where they had been told to stand. It would have been necessary to enter the bushy area itself, thus risking contamination of the crime scene. Now, all of this led to Hussein's defence lawyer arguing that because the 2 tit heads, my words not his, entered the crime scene to take photos whilst not wearing protective clothing, that could have contaminated the site, and that could explain Hussein's DNA at the scene. Thankfully, the dumbass actions of Lewis and Jaffer didn't cause the case to collapse, and Hussein was convicted and sentenced to a life sentence with a minimum of 35 years for both murders. Lewis and Jaffer first appeared at Westminster Magistrates Court on the 27th of May 2021, when each indicated an intention to plead guilty. The case was sent for trial at the Central Criminal Court. On the 2nd of November 2021, before the Recorder of London, the applicants each pleaded guilty on accepted bases of plea. In submission to the judge, Mr. Neil Saunders on behalf of Jaffer and Mr. Luke Pont on behalf of Lewis submitted that the judge had treated the general breach of public trust not only as an ingredient of the offence but also as an aggravating factor warranting an upward adjustment to the sentence. As a result, the judge had risked double counting by increasing the sentence on the basis of a factor already included in the nature of the offending itself. Saunders and Pont acknowledged the serious nature of the offence but submitted that there were important factors that reduced its gravity. Fucking can't see how you can reduce the gravity of that offence. Now, they submitted that the operational impact of the offending was limited. Any operational impact in the present case was a byproduct of, rather than the purpose of the offending. So, in other words, no operational harm had happened. There was no evidence that the crime scene was contaminated, and Hussein was still convicted after his trial. There had been operational risk, but the judge should have sentenced the applicants on the basis the risk was taken, at worst, recklessly. For these reasons, the offending did not merit moving the case into a different category of gravity. In response, Mr. Joel Smith, on behalf of the prosecution, submitted that the sentences imposed were not arguably manifestly excessive or wrong in principle. He argued that there were 4 factors to justify the length of the terms imposed. Firstly, the background was 2 offences of murder. Secondly, the misconduct created by 2 distinct breaches of trust, the general trust of the public that police officers will conduct themselves in an appropriate manner, and that officers were significantly entrusted to guard the particular crime scene. Thirdly, he emphasised the inevitable impact upon the family of the deceased. The actions of the officers had displayed a complete lack of respect or willingness to afford any dignity to either of the victims. And fourthly, the misconduct had put at risk the integrity of the murder scene and the consequential risk to the conviction of the man who was guilty of the murders. He added that the act of taking of the photographs was greatly aggravated by the dissemination of the photographs in the manner outlined. In the judge's closing statement, it was said that the culpability that falls to be punished by an offence must be reflected in the sentence that is imposed. In relation to the offence of misconduct in public office, the culpability lies in the abuse of public trust. In order to reflect the degree of culpability underlying an offence of misconduct, the starting point will be the offences involving a high degree of abuse of trust will attract longer sentences. We reject the submission that the abuse of trust inherent in the offence debars a judge from differentiating between higher and lower degrees of abuse on grounds of double counting. On orthodox sentencing principles, the more serious the conduct which the offence is intended to punish, the more severe the sentence. Nor do we regard it as necessary for a miscarriage of justice to have occurred before misconduct may be regarded as having an impact on police operations. The fourth principle in Bohannon suggests no such limitation. Bohannon relating to a previous ruling where the offender was a serving police officer who had provided sensitive and confidential information, which was considered appropriate case law for this particular case. In the case of a grave crime such as murder, in which there is intense public interest in bringing a perpetrator to justice, the risk of the police officer compromising a full and proper forensic investigation itself represents an acute breach of public trust that will increase an offender's culpability. I'm sorry if it's a little bit hard to understand exactly what's being said. I'm trying to quote the judge as best that I can, so I'm not misrepresenting anything that he's actually said. The impact of the misconduct of Lewis and Jaffer was clear. It enabled Hussein to rely on their offending at the murder trial to support what the jury concluded was his false defence. Although the jury rejected his defence, the misconduct of the police officers afforded him an opportunity to bolster his case, which imperilled the administration of justice. In sentencing Lewis and Jaffer, the judge was entitled to treat the misconduct as involving high culpability and to reflect that culpability in the sentences that he imposed. The misconduct also caused serious harm by taking photographs for their own inexplicable purposes. Both officers breached universal standards of decency, and they denied the two murdered sisters and their family the dignity and the respect that they rightly deserved. Both officers ought to have known the perils of unauthorised entry to the scene of a double murder, even if they didn't know they had received an instruction to stay in post, which they disobeyed. The purpose of the instruction was to preserve the murder scene, and it is in truth no mitigation to say that they did not appreciate what they were doing. Given the corrosive effect of such conduct as described, it is an aggravating factor that they shared images of the bodies with colleagues. In Jaffer's case, it was an aggravating factor that he shared an image with a member of the public, who was not subject to the authority or scrutiny of superior officers. An upward adjustment to their sentences was appropriate to reflect that particular additional harm. The appeal court judges ruled that the applications of Lewis and Jaffer for leave to appeal are refused, meaning that their appeal was, as we already know, rejected. Now, there's some information there that simply wasn't and won't be published by the mainstream media, and with the limited time frame I have for each story makes it impossible for me to add this level of information to everyday videos. But I wanted to give you guys an idea of what actually happened and how depraved some people really are in comparison to the actual facts that are disseminated by the mainstream media. Granted, the report said they had shared images of the deceased and even took the selfie and shared it. But the level of disregard to the lives of two innocent women cut down for no reason other than some fucked up lunatic wanting to win the lottery is absolutely disgusting. And for those of you who still like to deep throat cop and shine their boots with your tongue, I hope this gives an insight into the minds of some of the sick, twisted individuals we have allegedly protecting us. Now, I've linked the full judgment in the description below if you want to read the full 14 pages. But again, I wanted to give you an idea of the kind of thing that we don't hear in the mainstream media over certain cases. And I used this one as an example because it was a relatively recent case that most of you probably remember. If I had more time, I would probably try and cut that down slightly more and maybe rewrite most of that in my own words. But because it was a judgment, I have to be careful not to misrepresent what's been said. So, which has made this video a bit longer than normal. But if you've made it this far, thank you so much for watching. Isn't something that I'm going to be doing every day with all of my videos, as I've just said, but I thought it was important to share with you guys some of the things that we don't get to hear in the mainstream media.